Is there really a remedy? It's August 4th, 2026. Welcome to YesToHellWith.com. This is part 4 in a series about courts, the Constitution, and remedies. In the last video, I asked a simple but profoundly important question. If the Constitution limits government, where does the Constitution actually become a practical protection for citizens? We consider the example of a man restoring or simply parking a 1977 Ford Pinto on his own property. The city had adopted an ordinance prohibiting automobiles from being parked on front lawns. A code enforcement officer issued a citation. The property owner appeared before an administrative hearing officer and raised a constitutional question. But the hearing officer responded, "I apply the ordinance. I do not decide constitutional questions." The city enacted the ordinance and enforced it, and the tribunal applied the ordinance, and the citizen lost. But we are told that the citizen still has a remedy. He can pursue the matter through additional proceedings, seek judicial review, hire an attorney, file motions, prepare briefs, attend hearings, and if necessary, file an appeal. So perhaps a remedy does exist. But today I want to ask a different question. Is it a practical remedy? And therefore, is it a remedy after all? Suppose the citizen must spend 3 years pursuing a constitutional review. Suppose the legal expenses eventually are prohibitive. Suppose the case requires multiple appeals before any court meaningfully examines whether the government exceeded its constitutional authority. During those 3 years, what happens to the citizen? The citation remains, the fines may continue, the vehicle may have been moved or towed. The citizen may be forced to comply before the constitutional question is ever decided. The government acts first. The constitutional review comes later, perhaps much later. Now, consider the imbalance. The city already has attorneys. It has enforcement officers. It already has administrative procedures. It already has the public's money available to defend the ordinance. The entire process is set in motion immediately upon the citation. The citizen only has his own time, resources, and his own determination. The government may enforce the ordinance in days, but the citizen may need years to challenge whether that enforcement was constitutionally permissible. So let us identify the constitutional issue clearly. A right is one thing. A practical remedy capable of protecting that right is something else entirely. If the remedy arrives only after the citizen has paid the fine, moved the vehicle, lost the property, surrendered the license, or suffered the consequences of enforcement, what exactly has the remedy protected? If constitutional review is technically available, but not immediate, then obtaining it later after 3 years and extensive resources and multiple appeals, is the constitutional protection genuinely available for a free people? Or is it available only to those with enough money and time to reach it? But even then, I ask still, is it a remedy? Can it be considered a remedy? I'm not saying that every ordinance is unconstitutional. I'm not saying that every citation violates a constitutional prohibition of government authority. And I'm not saying that every administrative decision is improper. What I'm asking is something much more fundamental. When somebody raises a legitimate constitutional question, must he first submit to enforcement and then spend years attempting to establish that the government exceeded its authority? Is it fair? Is it just? Is it true? If that is the process, then when does the Constitution actually perform its intended function of limiting government? Before the entry, at the moment of enforcement, or years afterward? The Liberty Dialogue system teaches us to distinguish between the existence of a remedy in theory and the availability of that remedy in practice. It teaches us not to assume that because a procedure exists, the procedure necessarily provides meaningful constitutional protection. So here is the question. If enforcing a constitutional right requires extensive time and resources, has the constitutional protection become practically unavailable? Again, don't answer. Just think about the question. Because in the next video, we're going to ask, did the framers intend to create a system in which government could act immediately, but the citizen might not have that immediate satisfaction of a constitutional limitation? And as always, may truth reign supreme.